welcome you to another exciting session on CAMA 2020, that is the Corporate and Allied Matters Act, which was recently reviewed, which has been raising a whole lot of discussion. And for the organizers of this program, this happens to be the part 2. Part 1 was all about trying to understand the law, and that session was titled Understanding the Implications for Entrepreneurs and Businesses. And now we have gone into a particular area that has raised a lot of questions, and that is law, rights, and regulation of nonprofits. We have with us distinguished personalities this evening. We have no less a person than the Registrar General of the Corporate and Corporate Affairs Commission. He is Alhaji A.G. Abubakar. And honestly, we are so grateful to have you join us this evening, sir. You're very welcome.
Thank you so much. Thank you.
Thank you. Thank you once again, sir. We will be reading citations shortly, but we just want to welcome all our guests right now. We also have with us, before I introduce others, I guess I should introduce myself. My name is Fire Williams. I am the managing consultant of Simply Exponential Consult Limited. I am so thrilled to be here, and we are looking forward to this great discussion. So once again, the theme of this particular session is law, rights, and regulation of nonprofits. To take a little bit of housekeeping, the session is being recorded. Please keep your microphones muted at all times, except when you are requested to speak. If there are any technical issues, as we are living in the new normal, please put that in the chat box. Questions should also be put in the chat box, even though questions have been pouring in. So we will keep our guests on their toes this evening. Kindly participate in any polls that are set up so that you let us know how we're doing. The session is being transmitted live to YouTube and Facebook. Our Business Development Executive, Kike Lomo Bisheson, will be pasting these links in the chat box. Our first speaker for today is no less a person than the Managing Director of Partners CLB, barrister and solicitor. He is a 1980 graduate of the University of Ife, now known as Obafemi Awolowo University. He was called to the bar in 1981, holds a PGD in Maritime Law, MSc Finance, Financial Law as well. He has extensive corporate law experience, and he currently has founded the Center for Law and Business, which offers support for undergraduate and postgraduate degrees of University of London, development seminars, workshops, amongst other products. We are partnering on this session. Now, we have with us no less a person than Alhaji Abubakar. Alhaji, once again, you're welcome, sir.
Thank you so much for having me. Thank you.
You're welcome, sir. He is the new Registrar General, assumed duties. He is from Bauchi State. I used to be called Dan Bauchi, Alhaji. We have to.
You are still Dan Bauchi then.
I used to visit Bauchi State quite regularly myself. It is a beautiful, beautiful state. And he attended the prestigious Ahmadu Bello University, Zaria. He joined CAC in April 2004. He was a special advisor to Bello Mahmood, the then Registrar General. Prior to joining CAC, he worked with Nigeria's Social Insurance Trust Fund, formerly the National Provident Fund. He was also at NICON. Alhaji Abubakar is a member of the in-house committee on the review of Companies and Allied Matters Act, CAMA. He is married, and his hobbies include traveling and reading. Thank you very much, sir. It's a pleasure to have you. Hansatu Adegbite, she is the executive director of WIMBIZ, and today I got some expose that WIMBIZ is one of the first NGOs in Nigeria to be ranked 428 out of the 500 top NGOs in the world by NGO Advisor. Ladies and gentlemen, please join me in giving a big welcome to Hansatu Adegbite, Mrs. Hello, madam. Are you there?
Thank you very much, Mrs. Williams. I'm here.
It's very, very kind of you to join us this evening. And very soon, I'm sure by the time we have your paper, we'll be reading a complete citation. We have the next person on this guest list, and this next person I share a very special bond with because we were classmates at the International School Ibadan. He is Pastor Itua Igodalo, and his CV or his profile is several pages, but I have just confined it to one page. And suffice to say, let me introduce him properly, to say Pastor Itua Igodalo is a pastor, an accountant, a writer. He was born and bred in Ibadan and attended King's College, Lagos, as well as the University of Ibadan International School, where I met him. He obtained combined honors degree in economics and accounting in 1982 from the University of Hull, England, and attended the business certification course at the Harvard Business School in 2011. A whole lot more can be said about Pastor Itua Igodalo, and that would be just before his paper. We also have with us Mr. Timothy, Dr. Timothy Olawale. Dr. Timothy Olawale is the DG of Nigeria Employers Consultative Association. He is leading the foremost business membership organization, an authentic voice of business in Nigeria. Sir, there's going to be a big fight between you and the Lagos Chamber of Commerce over that session, but we shall leave that fight to another day. We are so glad to have him here with us. He was born in 1965. He is a consummate human resource management practitioner and accomplished labor and industrial relations professional. He is being represented by the head of legal, which is Mr. Thompson Akpabio. Mr. Thompson Akpabio, we are so happy to have you. So we'll just move quickly to say that comments and questions will be taken from our awesome audience. If you are not being asked to speak, please mute your microphones so that we can enjoy the session. I'll now like to hand over to Kike Lomo Obisheson to give us an overview of the agenda for today. Kike, over to you.
Thank you very much, ma'am. Hello, everyone. Please, if you are not speaking, please can you keep your mic mute?
I'll try and get that. Wow, we have a whole lot of mics to mute. Your microphones. Or Kike, please mute everybody else.
Yes.
Thank you.
Okay.
So please give us a review of the agenda for today. Thank you.
Thank you very much. So I think we're right on time. Mrs. Fire Williams of Simply Exponential Consult Limited has given us the profile of all our prestigious speakers and has said the opening remarks. The first speaker is Mr. Dakoyomi, Managing Partner of Partners CLB Barristers and Solicitors, and is also the MD of Center for Law and Business. That's one of the organizations bringing together this beautiful webinar. And he's going to speak for about 10 minutes. He's just going to give a brief presentation on the historical perspectives of NGO regulation in Nigeria and in comparison with other legal systems or legal regimes in countries around the world. And after which we'll have Alhaji Abubakar, the Registrar General of Corporate Affairs Commission, who will speak for another 10 minutes. After that, we'll take some questions and for about 15 minutes, and then we'll go back to the third speaker, Mrs. Ansatu Adegbite, the Executive Director of WIMBIS, who will speak for another 10 minutes. And we'll have Pastor Itwa Igodalo, Senior Pastor of Trinity Church. He will also speak on considerations for NGOs. And we'll have the fifth, but not the least speaker, Dr. Timothy Olawale, the Director General of Nigeria Employers Consultative Association, represented by Mr. Akpabio, Mr. Thompson Akpabio. He will also speak for just about 10 minutes before we then take the final question and answer session. And then we'll now have a wrap-up presentation from both the organizations that are presenting this webinar, Simply Exponential Consult and Center for Law and Business. Thank you. Over to you, Mrs. Williams.
Thank you very much. I think I'll just stop sharing right now so that I can invite the first speaker for the day, who is Mr. Dapo Oyewumi, a long-term friend and company secretary to Simply Exponential Consult Limited. He is going to be talking about evolution of NGO regulation. Thank you very much. Evolution of NGO regulation. You are welcome to take the floor, Mr. Dapo Oyewumi.
Good afternoon, everyone. Thank you for joining us again, for those who are joining us for the second time. As Mrs. Williams had said, we have done a session looking at the considerations for SMEs and enterprises. And today we'll be looking at the controversies surrounding NGOs. My session is to help to put things in perspective. For lawyers, we either start a foundation of anything at looking at a historical perspective, where we're coming from, to lead us to where we're going to, or a definition within context. I'll just give a quick example. The word church can mean the building, it can mean the congregation. So it's important that we know what we're looking at. So we're going to be looking at the perspective of the historical perspective of NGO regulation in Nigeria, how it used to be leading to where we are now. I believe everybody can see my screen, and I'll just quickly go on. I have only just about 10 minutes. Yeah, so that's that one. Quickly, I like to give the types of NGOs that we have so that we can also know that it involves a lot of other organizations. We have community-based organizations, friendly societies, social clubs, women groups, youth clubs, religious organizations, cultural organizations, trade unions, political parties, corporate societies, and specialized professionally run NGOs are all non-profits. So this law we're looking at applies to all of this kind of organizations. Then the legal form, how do you establish an NGO? There are two main forms, and both of them are now under the CAMA from 1990 till now. You have a company limited by guarantee. And examples of those NGOs limited by guarantee today that I am aware of, there's the MTN Foundation, there's the BATN Foundation, that's British American Tobacco, and the Life Changers Foundation. Then, of course, the Incorporated Trustees, which is under Part C of the present Company and Allied Matters Act. And you wonder what's the difference? Because both of them have charitable objectives. But from a practical point of view, I discovered that those who have a tendency for private sector orientation usually go by company limited by guarantees. That's why we can see the Life MTN Foundation, Life Changers, and BATN. While those that don't have that orientation seem to go by the Incorporated Trustees, which before now was the Land Perpetual Succession Act. Quickly going forward, looking at the law, it's a fundamental right in the Nigerian Constitution that everybody has a right to peaceful assembly and association. So we all must realize and accept and recognize the fact, appreciate the fact that it is a constitutional right to form an association. Of course, subject to certain restrictions. One of the restrictions is for political parties controlled by INEC. And then if there's going to be a conflict in fundamental human rights, and therefore public officers, it should not be incompatible with the functions and the dignity of their office as a result of the code of conduct, which itself is a constitutional issue. Statutory law, like I said, we have the Land Perpetual Succession Act, we have the Companies Decree 1968, and we now have CAMA of 1990 and CAMA that we're looking at today. The Land Perpetual Succession Act just simply said trustees, when they come together for a common purpose, will be registered by the minister, issued with a certificate of registration, and becomes a body corporate that can sue and be sued. There wasn't much regulation beyond that at that time. Oops. Okay, and then, okay, Land Perpetual Succession Act, I've done that. Then we have a company limited by guarantee under the 1968 Act. The 1968 decree at that time repealed the Land Perpetual Succession Act. So it's from then that we no longer had, I'm sorry. The Land Perpetual Succession Act ran side by side with the Companies Decree 1968. And the Companies Decree 1968 made provisions for companies limited by guarantee, as I mentioned above, for companies, organizations, and associations that wanted to form charitable organizations. Then the Companies and Allied Matters Act then repealed the Land Perpetual Succession Act in 1990 and made provision for companies limited by guarantee, as we know it now, and then for incorporated trustees, as it is today, pending the operation of the Companies and Allied Act 2020. The level of regulation and all that under these two acts was nothing close to what we're expecting today. And there are some which I would not go into because of time, how it's to be formed, and the issues about publication in the newspapers, the power of the Attorney General to accept and all that. Those are details that can be looked at. We're just looking at an overview. So the major amendment from the Companies and Allied Matters Act for incorporated trustees, there are a few amendments in section 823, 824, but the major one that's causing the controversy, and I think is the crux of this matter, is section 839. It gives the power to suspend trustees, appointment of interim managers, protection of the property of the association. All of these powers you will find in section 83923, on and on and on. The functions shall be performed by the interim managers or managers under the supervision of the commission. I think Alhaji Abubakar will be giving us a lot of details on that. But all of this, I must mention, must be backed by a court order. So the commission will apply to court and say, these things need to be done to protect an organization's property, or they're not doing things right. For example, it is fundamental that an NGO should not be running to make profit to distribute to its members. So if the commission believes that that is being flouted, then it might take necessary action. And all of these provisions are applicable to all of the non-profits that I had mentioned in the beginning of my slides. Everybody that's an NGO at that moment. In section 837, It may suspend or remove any trustee who has been responsible or privy to misconduct or mismanagement, can ask the order of the court for a scheme of arrangement, and may by order also replace a trustee removed under Section 7. The Commission can make regulations for the functions and powers of the interim manager, make reports to the Commission, and importantly, the Commission shall only exercise its powers under this section with the approval of the Minister. Then, a new innovation that we didn't have before is the establishment of administrative proceedings under Section 851. I'm sorry, that should be Section 851. This is an administrative committee that will be set up by the Commission to look at any grievances. So it's like the first step in the event of any grievance or any member of society or any association not being happy with the actions of the Commission. So that's the first step. They will look at it, you make your presentation, and a decision will be made. If, however, the association or the person is not happy with the decisions of the administrative committee, then you can appeal to the Federal High Court. So that provision is now there. And then, as Mrs. Williams said, I did a quick jurisdictional comparison with just two countries who share Commonwealth and common law traditions with us. I looked at Ghana. What do they have for NGOs? For them, primarily, they have a new act also called the Companies Act 2019. It was enacted only last year. And for them, the primary legislation is the act, and the company is a company limited by guarantee. There are no far-reaching regulation like we have under the CAMA, save that normal things, you must hold an AGM, you might have an extraordinary general meeting, you must publish your accounts, you must register your accounts with their own equivalent of the commission, you must have directors, the directors have a duty to the company, and all those normal kind of provisions that they have. But importantly, every organization that wants to operate as an NGO in Ghana must obtain license from the Department of Social Welfare. So you incorporate under the commission, their own equivalent of the commission, and then go to the Department of Social Welfare to register there. It's only after you've been registered by the Department of Social Welfare does the organization get recognition as an NGO. But again, it doesn't seem, the major criteria for the social welfare department seems to be the issue of public trust, public confidence, and tax.
2 minutes
make sure that,
more, sir.
Okay, so
sorry,
that's that.
Just 1 minute
then,
in fact.
No problem. Then I quickly looked at the UK. The UK has a Charities Commission. They did not mix up charities in the Companies Act. They have a Companies Act 2006 that underwent a massive review from 1997 up to. So charities is a totally different subject, and there's a charity commission. But let me quickly say, the commission is a non-ministerial government department, essentially has a government role, but it is not part of the government department and operates at arm's length from government. That's the commission. And then the Charities Act of 2011 empowers the commission. One thing I would quickly like to draw attention to before fire drives me off the screen.
I am already.
Just 1 minute, I think this is important. Oh, okay. Sorry. Yes, the commission, the UK commission, in what I'm showing, seems to have power similar to what we have here. Suspension of trustees and appointment of interim managers, offense of contravening certain orders under Section 76, interim managers, removal of trustee of officer for protective purposes, other powers to remove or appoint charity trustees, removal or appointment of charity trustees, removal of trustees, power to suspend or remove trustees from membership, power to direct specified action to be taken, power to direct application of charity property, copy of certain orders and reasons, supervision of commission by certain Scottish. So of course, with that, we can't go into details, but at least that gives us an inkling of what we have in the jurisdiction from which we took our own matter. And so I will end here, although I have a question that says, what we have now, is it regulation or over-regulation? And I thought that the considerations in answering that question is probably a reflection of the times. We know that there's a lot of abuse going on these days, scams and things like that. There's fear of terrorism financing, abuse of powers, misconception of the purpose of nonprofits. Some people think a nonprofit is a business. You hear people say, oh, I run an NGO as a business. Of course, the big brother syndrome is government overbearing and looking other people's over our shoulders all the time. The court has a strong influence and role to play in this act. And of course, the administrative proceedings, and of course, the role of the supervising minister. So all of these powers that seem to be such a problem are subject to the powers of the court and the role of the supervising minister. So when we look at all of these considerations, what we will answer is this a regulation or over-regulation? Let me stop here before Fire imposes a fine on me. Thank you for listening to me, and we look forward to hearing the others as they speak. Thank you.
Thank you. Thank you very much, Mr. Dapo Oyewumi. You took us through the evolution of NGOs. I have never had so many laws. You started, with, you mentioned the Companies Decree 1968, told us some of the provisions in there, and then how the Corporate and Allied Matters 1990 made provision for companies limited by guarantee as well as incorporated trustees. You did mention something about the power of the Attorney General to accept if if a body wishes to register as an incorporated trustee. I know some people have had some issues with that, in that probably it might cause some delay. So in the next, with the next speaker, who is our distinguished Registrar General, I might like him to please address that issue, that sometimes, when papers need to go through the Attorney General, they may be subject to delay. And therefore, Oyewumi anchored his presentation on the powers of the Commission to act for protection of charities. He took us to Ghana, he took us to the UK without leaving the shores of Nigeria. And he gave us an overview of what happens in other climes. Thank you very much, Dapo Oyewumi. And now we would like to invite the Registrar General of the Corporate Affairs Commission, the man who is currently, I would say, at the eye of the storm, because he is receiving questions from left and from the right on this newly revised law. Once again, he joined the CAC in April 2004. He was a special advisor to the then Registrar General. He has worked with the NSITF, and he has worked with ICON. He's a member, Governing Council, Nigeria Bar Association, Section on Business Law, member, Interagency Committee Against Money Laundering and Terrorist Financing, 2007 to date, a CAC focal person on open government partnerships, amongst others. Once again, it is my great pleasure to welcome the Registrar General of Corporate Affairs Commission, Alhaji Abubakar. You are welcome, sir. You have the floor for 10 minutes. Please, could we unmute Alhaji Abubakar? Just a minute. Admin CLB, Kike Obisheson, please unmute Alhaji Abubakar. Alhaji, please just give us a minute. That will be done. Just give us a minute. I'm sorry. This new normal. Some getting used to. Alhaji Garba Abubakar, have you been unmuted, sir?
Yes, thank you so much.
Yes,
Good,
please.
good evening once again, distinguished participants and other panelists. Mr. Oyewumi has done half of the work. He has given an excellent background to the evolution of the various provisions on registration and regulation of not-for-profit. Unlimited by guarantee, I will just add that the new CAMA under Section 26 has now given time frame within which the Honorable Attorney General should give his approval for the registration. If after 30 days, the approval is not granted, then the trustees can publish in 2 newspapers, and after 28 days, CAC can proceed to register. So for incorporated trustees, sorry, before I go to incorporated trustees, limited by guarantee are companies. So they are governed by the provisions of governing companies, whether limited or unlimited. The only difference has to do with what they do with their income and property. But matters relating to meetings, qualification for directors, and other matters also applies, as in the case of other companies. For incorporated trustees, the law has now changed the minimum requirement of trustees. Under the former law, 1 person can be a trustee, but under the new 2020 Act, you must have a minimum of 2 trustees. But the objectives for which these associations can be established remains the same. The law says where 2 or more trustees are appointed by any committee of persons bound together by custom, religion, or kinship, or where any body or association established for any religious, cultural, and such other purposes. The major changes relates to the issues of suspension of trustees, issue of dormant accounts, and issue of filing of audited financial statements with the CAC. This has generated a lot of controversy. In my view, the controversy is actually unnecessary. The bone of contention has been section 839 subsection 1, where the law says the CAC can by order suspend a trustee on grounds of misconduct, misappropriation, or where it becomes necessary or desirable for the purpose of protecting the property of the association or to ensure proper application of this property, or where there is fraud or on grounds on public interest. CAC can suspend, but we should read the provision of section 839 subsection 1 in conjunction with section 839 subsection 7A that requires CAC to institute an inquiry before such suspension can be carried out. And I will not agree with the position of Mr. Oyewumi that CAC needs the court to suspend on the grounds enshrined under subsection 1. It's only on circumstances under subsection 2 that CAC may have to go to court. On any of the grounds provided in subsection 1, CAC can suspend without recourse to the court and appoint an interim manager. But CAC cannot replace a trustee without recourse to the court. And CAC cannot suspend other officers of the association or the governing council without recourse to the court. But for the trustees, CAC can suspend. Why did we have this provision? As Mr. Oyewumi has rightly observed, the legal framework for the regulation of incorporated trustees was based on the provisions of the Perpetual Succession Act. We've not had the benefit of any change in that law up to the time, for the 30 years it has been in operation under CAMA. Even before CAMA, it was, I think, a 1946 Act that was moved to CAMA. So, 48 Act. So there have been a lot of changes on the regulation of not-for-profit organizations globally. Nigeria cannot afford to be different. And ordinarily, CAC does not even have to exercise this power if the association, through its members, who have the right under the Constitution to appoint or remove trustees, exercise that power. Because the law says the power to, all these things, the way the trustees are appointed and the way they are removed should be provided in the Constitution of the association. But most of the associations we are referring to, what is the role of the general members? How many of them actually hold meetings? And in most cases, particularly for smaller associations, there is no distinction between the general membership and even the trustees. So where there are grounds of misappropriation, misconduct, fraud, do you have to wait till eternity? You can't see a trustee removing himself. So you need an external authority that has oversight over this association, exercise this power. And can the CAC on its own or without recourse to anybody remove a trustee? The law says under subsection 7, the law says there must be an inquiry. And I'm glad Mr. Oyemi has alluded to the provisions establishing an administrative proceedings committee. Our own position is that any such inquiry will be made under the auspices of the administrative proceedings committee. And the person that is alleged to have made this infraction is entitled to be heard, is also entitled to legal representation. And even after the committee, which will be chaired by the Registrar General with 5 other directors as members and a representative of the Ministry of Industry, Trade and Investment as member, even after the committee has come up with its decision, the report must be referred to the board of the commission for ratification. The board of the commission has about 12 members, including representatives of the Bar Association, Manufacturers Association of Nigeria, ICSAN, NASIMA, MAN, Ministry of Trade, Ministry of Justice, Ministry of Finance. You have 12 members that will still have the opportunity to review this report. After their review, the report has to be referred to the Honorable Minister of Industry, Trade and Investment for approval before the trustee can be suspended. So this is not a power.
Hello, ladies and gentlemen. I am sorry, it appears as if our distinguished DG possibly ran into a technological glitch. This does happen once in a while. I'm afraid he is off the radar right now. We would look forward to having him back. Alhaji Abubakar, as soon as you can re-establish connection, please let us know. And in the meantime, we have the Q&A session. So Mr. Dapo Oyewumi, you will please do us the honors of answering some of these questions. And I guess even our other distinguished speakers, Mrs. Adegbite, Hansatu Adegbite is around. Pastor Itwa Igodalo is also on this call. I'll just go straight into some of the questions we have. So number 1, I have a comment here. I don't think it's necessary for government to intervene in affairs of the church. It's an NGO and their operation should not be determined by a political office or political officer. I think the DG might be the best person to answer that. What do you think, Mr. Oyewumi?
I believe so, the DG. But if I may refer to what he has said, okay. You know, he had made strong references to inbuilt checks and balances.
Mm-hmm.
And in my presentation, I did say the law is applicable to everybody that I had listed. So it is not discriminatory.
Okay.
It is not targeted at religious organizations, whether church, mosque, or atheist organizations. It is all NGOs.
Use.
So it is not discriminatory. And those inbuilt checks, you have to get an order of court. You can go to the APC, has to look at it first, the administrative committee. It's told us who members of that committee are. After that,
about 12 members.
Yes, apart from the committee, then the board, and then from there it goes to the minister before it then becomes. So there are inherent checks and balances. And again, if you look at my reference to the Charity Commission in the UK, where I'm not saying that we must copy wholesale whatever other people are doing, but it's a good reference point. There seem to be similar provisions there. And again, I think this might be a reflection of the times.
All right, I need to jump in here because Pastor Itwa Igodalo is an affected person.
Yes.
And I would like him to also weigh in on this. Pastor Itwa, it's nice to see you here. We're a long way from school. Sorry to put you on the spot, but it is true, you're an affected person. As the law would say, so please could you weigh in on this? Is it necessary for government to intervene in the affairs of the church, being a non-governmental organization, and the operation of government is only for politics? That is what one person has said. What's your view, sir?
You make me sound as if I'm an affected person in an IDP camp.
We pray not. That wouldn't happen, sir.
You know, there is a natural suspicion from the church. There is a suspicion from the church that government is trying to find a way to muscle the church and to gag the church. The suspicion didn't start now. It started from perceptions of Islamization. It started from the Financial Reporting Council. We had a lot of debate with the Financial Reporting Council where the church also felt this NGO business was targeted at the church. And then recently there was another commission set up to try and regulate charities and all that. But from a very, very objective and truthful perspective, it is government's business to regulate and to provide a level playing field for everybody. It is also possible that some people in government might have an agenda which they can push through very, very subtle methods and things like that. It is possible, it does happen everywhere in the world. Politics and all that is about agendas and all that. But that does not prevent the government, and the government should not be intimidated from performing its role as an arbiter, as a regulator, as a person that imposes regulation to the members of the public. I was explaining to some of my people today that once you are born into Nigeria, you're a citizen of Nigeria, you have the responsibility of the Nigerian government, good or bad. Okay, that's why America will send its troops to go and rescue an American citizen from whatever problem they have. Maybe Nigeria hasn't gotten to that level, but we are responsibility of the government and there must be regulation. What we want to ensure is that the regulation is fair, the regulation is reasonable, the regulation is not targeted to victimize or prevent certain people from conducting their affairs, and the regulation is not discriminatory. Once we are assured of that, it is fair, it is reasonable, it is not targeted, it allows for a level playing field, and it allows for people to be able to do their business and express themselves without fear or inhibition. There's nothing wrong with being regulated. The government is there to regulate people. So what we should be doing as religious bodies or churches is to look at this regulation that the government is coming up with and ensure that it passed the test of being fair, being reasonable, being focused, not intimidating, and not trying to prevent us from doing our ecclesiastical duties. What I was trying to say is that it is targeted towards NGOs as a body. So on that count, it looks as though it passes that test of not being discriminatory. But then again, you know, sometimes when some people want to be mischievous, some innocent people get carried along in the wake as well. So the church is still looking at that to know whether indeed this is what it is. But regardless, I think the important thing is to look at that regulation itself and be sure that it is fair, it is reasonable, it is not targeted, and it does not prevent the church from doing what the church wants to do. I think I will take a break here. And if you want me to further look into the regulation itself, I can do that later, but I want to yield the floor at this point in time.
Thank you very much, Pastor Itwa Ighodalo. You have spoken well. You have said so far these laws are fair, reasonable, non-discriminatory, and provide a level playing ground. It is the duty of government to regulate. There are several comments here. We have someone saying we are not opposed to regulation of NGOs because any institution without regulation is set up and bound to fail eventually. I think that's just a comment. My question is, why should the commission be empowered to sack trustees duly voted in by me? I think that, Dakwa, can you attempt to give an answer to that? On what grounds does the commission come in to sack trustees? There are certain, I believe there were 5 grounds. Please, could you explain further?
Okay. One of the grounds is fraud. If the activities of the association is being carried on in a fraudulent manner, if the assets and the properties of the NGO is being misappropriated, it's also important to protect even the NGO itself and its assets and properties. And if there's misadministration or maladministration in the affairs of the association, then the commission may set up an inquiry to look into the affairs and then come up with that decision. It's not as if the commission will just wake up and say, we need to do this. And of course, to suspend, it needs the order of the court. Suspension and removal need to go to the court. And of course, if you go to court, you must present papers, you must present grounds upon which you want that removal to be done. And the court is meant to be an independent arbiter on its own, with the judge and all that we all submit to. So that will also, he would also look at that before making a pronouncement whether or not the suspension or removal should be made, or make some other alternative orders for that may be necessary in the circumstances.
All right. Thank you very much. There is a question here or a comment.
Let me just quickly add.
All right.
That we have NGOs, including churches in Nigeria, who operate in other jurisdictions, including the UK, which is one of the reasons I chose the UK. And they're subject to the laws of the UK, the Charities Act 2011, and the Charity Commission that I mentioned, with those powers that have been listed, which seem similar to what we have. I just thought it would be nice to put that perspective.
Sorry, Mr. Can I also butt in a little bit?
All right, Pastor Itwa wants to jump in at this moment. Yeah.
Yeah. Like Dakwa said, a lot of our churches have branches in the UK, even in the US. So for those who are in the UK and the US, it is not unfamiliar. As a matter of fact, one of our leading churches went under the Charities Commission about 4 or 5, maybe almost 10 years ago, to be honest. And it went through a little bit of a traumatic experience, but nonetheless, nobody could say that the Charities Commission had acted outside its ambit. What we need to be careful about here is this. The church itself or the NGO itself has a constitution, and the constitution or the memo or the articles will define what among the members of that organization is whatever it is. So things like fraud, things like protection of assets, things like that. There's, in law, I'm sure there is an arbiter of reasonability, but then within a group of people who freely want to associate, they can also have their own basis of association. So the Charities Commission or the CAMA needs to define for us what is superior. If the organization has a constitution and the constitution allows for certain things and the members have agreed to that constitution, can CAMA or the CAC now come and say that their constitution is wrong when we all have agreed amongst ourselves that this is how we want to operate? So we need to be careful about the interpretation of certain things. What will constitute a fraud in a certain place may not constitute a fraud in another place. What will constitute an abuse of use of assets in a certain place may not necessarily be the same in another place. So we have not quite defined what these things are to the extent to which we go and the role of the constitution of that organization. We must try our best not to make anything too arbitrary and too judgmental. Otherwise, we may get into some kind of sticky areas. That's what I wanted to add at this point.
All right. Thank you very much, Pastor Itwa. I believe I saw some reaction from Dako Yeumi. Would you like to respond to that very briefly?
Okay. Quickly, I want to say, even before the Constitution, the Constitution has to be registered with the CAC. Okay. So I'm trying to support that. So the Constitution was approved by CAC. So so that Constitution is valid. It meets the requirements of CAC. If there are any things that are not acceptable, the CAC would have asked you to remove it before you register. So I agree that you can have worked with your Constitution. However, there are certain rules that are standard. Fraud has a definition in law. It's not subjective. Certain behaviors too are not subjective. They have their standards. And then there's something which I think this whole idea is all about. And that happens in any organization where there's a majority and there's a minority. And if it's the majority that is carrying out the fraudulent act or the maladministration, and they're the ones in charge, let's say, for example, it's the trustees that are doing anything wrong, they won't take themselves to court and they won't remove themselves. And then the minority will then be there grumbling, growling, and not being able to do anything. If it's under company limited by shares, there's a procedure for minority protection, but that procedure is not applicable for incorporated trustees. Perhaps, although there's a provision here now that 1/5 of the members can ask for certain things to be done. So perhaps it is for those kind of situations where the majority who are in charge are those doing the fraudulent things that perhaps the commission. But this is a new law. It's going to be subject to interpretation. It's going to be subject to implementation, debate, and it's going to, a lot of cases are going to go to court for interpretation. There's no doubt about it. I have seen some myself where words are used interchangeably, and things like that. So perhaps this is a new venture for lawyers.
I don't know whether this is a new venture for lawyers, but just before we go into that terrain, I would like to announce that Alhaji Garba Abubakar is back with us, sir. Can we just hear from you?
Thank you.
Okay, and there's a comment here that really rounds up all we have been saying. It says, it's part of good governance for all organizations, including religious bodies, to embrace the principle of good governance. They must be held accountable for the trust, particularly how they administer the assets of such organizations. No sentiments. And I think even Pastor Itwa Ighodalo was saying something about this. So Alhaji Abubakar is back. Sir, do you have your last final words on what you were discussing before the technology took us a bit out of sync?
Yes, I was actually speaking about the issue of dormant bank accounts. I was saying that an organization that is established for a particular objective, why should they leave money in their account for 5 years without doing anything with it? And even the power given to the CAC to transfer the balances to another NGO is not absolute. There has to be an investigation first. CAC has to find out from that organization whether they're still carrying out activities. If no response is received within 15 days, then CAC can direct that these funds be transferred to another organization so that this money can be used for a particular activity, for the purpose for which it was intended. And one thing we need to understand, and it's good to emphasize this, the major difference between not-for-profit and businesses is even where you are the sole donor to this organization, the money does not belong to you. You are supposed to apply strictly for the promotion of the objectives of this association. And the law says you are not entitled to remuneration, you are not entitled to any bonus. It's only where you are in the employment of the organization that you will receive salaries based on the services you actually render. But as a trustee, we are only entitled to be refunded your reasonable out-of-pocket expenses. So this is a major distinction. And Mr. Oyemi has alluded to this. The fact that in most of these organizations, there is no difference between the trustees and even the members. So where there are infractions, how do you expect the trustees to suspend themselves? Ordinarily, the Constitution provides the criteria for appointment and removal of trustees. But where the trustees are also the members, and I can tell you, most of the organizations being registered with CAC, you will see, because they are supposed to show the voting pattern on how these trustees are elected, you will discover that the number of votes for or against is actually exactly commensurate with the number of trustees that they are registering. So the impression we have is as if they don't have any other member apart from the trustees. So this law is not targeted at any group or individual. It's intended to strengthen our legal framework, ensure accountability, and the new requirement that the association must also file biannual statements. Our regulations will define this biannual statement, the content of this biannual statement, and they are also required to audit their accounts and submit audited financial statements together with their returns at the end of the financial year. So all these measures are necessary because take, for example, an association that is established with one of its objectives as election monitoring, where its donations are received. And these donations are applied for a different purpose. This is a misappropriation, even if they use it, let's say, to build properties, housing estates, or schools. If this money is not used for the purpose it's intended, that's misappropriation. So, and for an association, sometimes it's husband and wife, but the donors may not be the members. It may be an outsider. So all these provisions are necessary because it will give comfort to even foreign donors that bring their money to Nigeria for a particular cause. Because what some of them are doing, they come and operate without even registration because they can't trust some of our local NGOs for some of these activities. They come, they go to Ministry of National Planning, they get approval, they execute some of these projects directly. And finally, unlike companies where the law says, if you are carrying on business under a name other than your full name and surname, you must register. For associations, it's your constitutional right. You don't need to register. So anybody that doesn't want to submit himself to any regulation, if he feels he can operate his organization without registration, and his members can trust him, can make donation to him as an individual, because I can't see any bank giving you opening any account for you in the name of an association that is not registered, then he can operate in that manner. Nobody will question him. But where we choose to register, we must submit ourselves to regulatory oversight. And CAC has been regulating companies for over 30 years. We have powers to investigate the affairs of companies. Although until now, we didn't have any power to revoke certificate or cancel certificate or suspend. But the assurance I want to give to the public is our powers are not absolute. They are subject to checks, even though Mr. Awemi keep making reference to the court. I still stand by my position that under 839 subsection 1, CIC can suspend, but CIC cannot suspend. So these are necessary checks. And any aggrieved party can challenge the decision in court. And the issues have been, reference have been made to the Charities Commission in the UK.
Yes.
The Charities Commission under the Charities Act has concurrent jurisdiction with the High Court in England. And the Commission can suspend on all grounds. On all grounds. They don't even need the court to do anything. So, but for under our own law, the suspension can only be on the grounds. CIC can only suspend without recourse to the court on the grounds stated in section 839, subsection 1. On other grounds, CIC has to go to court. And why it involves the governing council or the officers of the association, CIC has to go to court to suspend. But all these are subject to the, when it goes to court, these issues can be reviewed in court if the court is not satisfied. And even after the suspension, an aggrieved person, as I have said, can go to court to challenge the suspension. Sometimes it may be necessary to preserve the rest. Because if you allow the same trustees to continue in office with all these infractions, by the time you finish the judicial process, there won't be anything left for the association. So these are preservative measures so as to safeguard the property of the association or to curtail fraud.
Thank you very much, sir. We are really running a bit out of time, but we do have some questions for you. Somebody wants to know, Adirogba wants to know, was there any public hearing from the National Assembly before the new bill was passed? Was there any public hearing, sir? Were stakeholders invited? Sorry, Alhaji Abubakar's mic seems to be muted. Sorry, sir, please, could you come again?
Yes.
The question is, was there a public hearing?
Very well, there was public hearing at the Senate and the House of Representatives. Okay. We need to know the history. This law started with the ex-assembly. It was passed by the two chambers of the ex-assembly, and it was transmitted to Mr. President for assent, just towards the tail end of the ex-assembly. Unfortunately, the assent was not granted, and almost the same bill was represented to the Ninth Assembly. And by the various rules of the two chambers, where a bill had been considered and passed in the past, it doesn't go through the process of another public hearing. But there was a public hearing in 2018 when this bill was considered. Yes, secondly, this bill was not just CAC that worked on this one. We had different stakeholders involved. We had the Nigerian Economic Summit Group. We had the Nigerian Bar Association section on business law. In fact, the first draft was prepared under the auspices of the National Assembly Business Roundtable, because we had two private member bills initially, which we didn't agree with. So we submitted our own draft as an agency. A committee was constituted by the ex-assembly under the auspices of the National Assembly Business Roundtable to harmonize the various submissions. And they came up with the final draft that was eventually passed by the two chambers. It was this final draft that was actually represented as executive. The only change, because the bill that was passed under the ex-assembly had removed the role of the Ministry of Justice, the role of the Attorney General with respect to registration of companies limited by guarantee. So the ministry, that provision was restored with some amendments that if the approval is not granted within 30 days, then the owners, the applicants can do a publication. And after 28 days, if there is no objection, CAC can register. So that was the only provision that was changed. But in all material respect, the provisions under the bill that was passed by the Ninth Assembly was the same with what the sorry, by the assembly was the same with what was passed by the Ninth Assembly.
Yes,
Yes.
sir. Sir,
Thank
there's
you.
a more focused, there's now a question on section 839. Dapo had mentioned earlier that this is one of the most controversial areas, and the question goes thus: does it presuppose, that there are scenarios under which the commission can suspend or remove without an order of court, i.e.,
Yes.
after their own internal investigation? That is, after CAC has done internal investigation. And as a rider to this question, section 839 subsection 7 of CAMA 2020, are there, do you have removals? The removals and suspensions, are they only done after obtaining a court order? So this is a double-sided question. Somebody wants to...
Okay, thank you so much. You see,
Yes,
I must admit, the drafting of those sections were very inelegant. They were very inelegant. The sequencing of the provisions were done in a very haphazard manner. But we should read section 839 subsection 1 in conjunction with section 839 subsection 7A. And on grounds outlined in 839 subsection 1, that is on grounds of misconduct or misappropriation, or for the purpose of where it is desirable to ensure to protect the property or ensure proper of the property, or where there's a fraud on grounds of public interest, CAC can suspend. Our position is CAC can suspend after inquiry, in line with section 839 subsection 7A, without a cost to the court. But these are defined grounds. But on any other ground, CAC has to go to court. So this is actually our position on this. Yes, on any other grounds, CAC has to go. And as I've said, it may be necessary to suspend so as to preserve the rest.
Yes,
because
sir. You
where
did
there is
say
no
so.
difference between the trustees and the members, and somebody had done all manner of things, if you leave him in office, by the time you are ready to suspend, or by the time you finish, because one thing with us as Nigerians, we use the judicial process to delay things and to scuttle sometimes, even to circumvent some processes, because we know that the process may be slow and cumbersome, and we use all manner of rigmaroles to delay the process. So,
all right,
as I have said, our powers as commission is not
okay. We seem to
Oh,
have, okay. Just
What
the
is-
final comment now, sir. We've heard you on that the powers of CAC are not absolute, and that you need to preserve the rest. That's why sometimes the people in there need to, they need to step aside while the investigation is going on. But we have another comment here that says the Charities Commission is an independent, non-ministerial government agency and cannot be placed on the same pedestal as CAC. Since CAC is directly dependent on the government, probably for budget, running expenses and all that, it is considered that CAC may be easily influenced by government officials. What is your take on this, sir?
Oh, okay, my take on this is even the courts receive money from government. Even judges get salary from government. Even judges. Supreme Court is still not independent.
All right,
they are in the budget. So we are a responsible agency.
Yes, sir. Thank you. Thank you very much.
True.
We understand you. Even the judiciary receive money from government. All agencies do, but we can still, act responsibly. And on that note, it is my pleasure to invite the next speaker for the day. That is Mrs. Hansatu Adegbite. She will be coming on right now. She is the executive director of WIMBIS. WIMBIS, as I mentioned before, is a foremost NGO, and they are ranked 428 out of the top 500 NGOs under the NGO advisor. Ansatu is a graduate of Business Administration from University of Abuja. She graduated with an MBA from the Business School of Netherlands. She is an alumnus of the Harvard Business School and Enterprise Development Center. She is a SMEDAN certified business development service provider in Nigeria, trainer and life coach. She has over 25 years collective experience in banking and entrepreneurship in the social sector. She is going to be talking about CAMA 2020, the funding question. And Madam, you have the floor.
Thank you so much, Mrs. Williams. I just wanted to mention that WIMBIS, for those that don't know, is Women in Management, Business and Public Service, which is a 19-year-old NGO in Nigeria, founded by 13 individuals, 12 women and 1 man. And ironically, it was the idea of the man. I think it's important in touching the funding space to mention that for NGOs, I think the concern, just like Pastor Itua Ighodalo has pointed out, even as pertains to every NGO and the CAMA, is that people just want to be sure that the processes are, even from the point of checking fraudulence, misconduct, mismanagement of funds, is actually free and fair and not targeted. Because you wonder in the CAC, I don't know what the statistics are in terms of the number of NGOs that are registered in Nigeria and the number of incorporated trustees. So you want to ask even the CAC, what is the criteria they will use to begin to identify most of these organizations that misconduct and operate fraudulently, because we're dealing with hundreds of thousands of organizations. But having said that, when we talk about the funding space, one of the things that WIMBIS is actually known for is integrity and having very good processes in place as it pertains how we manage our funding and even our corporate governance structure. And so I'd like to quickly mention that our founders actually started the organization themselves 19 years ago. We have very reputable founders in our organization, people like Mrs. Adiola Aziz, Dr. Ibukun Awoshika, Dr. Omobola Justice, Mrs. Ibukun Awoshika, Mrs. Ifeanyi Ighodalo, to mention a few. Now, when they started the organization 19 years ago, they ran it themselves for 10 years. When they had established a very concrete foundation for the organization, they handed it over to the next generation they started grooming the next generation of leaders to also run the organization and put a lot of processes in place. And so when it comes to funding, we do have various avenues of funding. First of all, it's a membership-based organization, so members pay dues. We have donors, international and local donors that also contribute through grant contributions. We have a lot of programs that are sponsored by the private sector, and all our programs have committees that are put in place to ensure that the fundraising processes are very clear and strategically done. Now, having said that, we also have a structure whereby we have a finance committee made up of members of the Executive Council of WIMBIS, and then we have an audit committee, which is chaired by a member of the board of WIMBIS, has the 1 or 2 members of the Executive Council and members of the association that are tried and tested and known as credible people in the organization. So we hold ourselves accountable internally. There is no fund that comes into the organization that does not pass through an account, that is not audited, that does not have reports, because we do submit monthly reports to the Executive Council, to the boards, and every quarter, the board also goes through our accounts. Our audit committee at any point in time ensures that we are compliant with whatever we're doing. And for all grants, and it's very important for most of the non-governmental organizations to also note that for any kind of grant you're applying for, especially international grants, they don't give you money just because you are an NGO. They check your processes. You have to submit certain types of financial reports, audited reports, and all that. So they also do their due diligence on your organization before you have access to funding from such organizations. And even when they give you that money, they want to ensure that you have used it for what you applied for. And so there are certain reports you will submit at different points in time of that grant circle. And at the close of the grant, there are certain reports again that you will submit. And part of those reports is the financial report. And so WIMBIS is an organization, just like Mrs. Williams had stated earlier, that has also been assessed by the NGO advisor in Switzerland and is the first indigenous NGO to be actually seen to be having all the processes in place and worthy of being rated on that scale. So having said that, because these processes are in place, it is very difficult as an NGO to be found to have misconduct, mismanagement, or fraud, especially when you have a proper corporate governance in place. And one of the things we have also put in place is that our trustees don't manage our financial accounts. We do have one or two of them that sign when it's a particular threshold, but even that has a number of approval processes and a number of signatories that sign and get that approval. And so what I just wanted to mention in terms of the funding space is that once you have the right processes in place, the right people, you have people that can hold you accountable, and you also have, we have auditors that also audit our accounts at the end of the year, and they do point out one or two things, then it is easier to not have any issue with the CAC or any kind of government regulation as is. It is, however, important to note that not all NGOs have these type of structures in place, and not all of them can even afford to put some of these structures in place. So it's very important to even be able to sensitize some of these NGOs to be able to do things on their level, and also for the government to find ways of even also assisting some of these NGOs to just have things in place. So some of us are very lucky that we have the kind of experienced professionals that ensure that we are held responsible and accountable. But for those that are not really in that space, it is our collective responsibility to ensure that we do put one or two of these things in place and find out what we need to do and to do them properly. So I just wanted to mention that when it comes to funding, once you know that you have the right processes in place, then I don't think you have any issues or concerns as it pertains to what the CAC or the government is doing in terms of regulation, as long as it is free and it is fair. So thank you, Mrs. Williams.
Thank you. Thank you very much, Mrs. Hansatu Adegbite. You have said it rightly. Once you have the right processes in place, you have a system of audit, you have separation between the trustees and the people who actually manage the finances, then one should not have any fear of regulation by government. And we would now like to ask you to just relax a little, because there are a lot of questions, while we invite the affected person, Pastor Itwa Ighodalo. I hope this will not become your new name today. It's nice of you to join us once again. I really crave that relationship. When we were in school, we didn't know that he would become a famous pastor like this. We would have, asked for more blessings, but we're still asking for those blessings even today. Thank you very much for joining us, Pastor Itwa Ighodalo. Pastor Itwa Ighodalo is a member of CAO Professional Accounting Firm. He's one of the partners, I believe. They provide audit, tax, and advisory services to leading indigenous organizations. Is the 5th largest accounting practice in Nigeria today. He is a fellow of the Institute of Chartered Accountants of Nigeria and also the Chartered Institute of Taxation, as well as the Nigerian Institute of Management, and a member of the American Society of Industrial Security and member of the American Institute of Management. He sits on the board of several companies, chairing some of them, some of which are Famad Nigeria PLC, Elizabeth R., owned by his late wife, Trinicorp, Tri-Contract, Capital Gate, Pioneer Trust Microfinance Bank, Hebron, and many others. He's also on the board of several charitable organizations and NGOs, including Courage Education Foundation, Eden's Fields, Health Initiative, Stephen Adams Social Reformation Foundation, Liberty Homes, and many more. He gave his life to Christ in 1993 and was ordained an assistant pastor in the Redeemed Christian Church of God in 1995, while in the city of David, VI, he became a full pastor of the Redeemed Christian Church of God. He was actively involved in setting up international missions and helping to pioneer several RCCG parishes locally and abroad. He is a Christian of great repute who practices what he preaches, and he is currently the pastor in charge of Trinity House, a non-denominational, free-flow Christian worship center. And today, we are very, very happy to have Pastor Itwa Ighodalo. You're very welcome, sir.
Thank you very much. Thank you. First of all, let me thank you, Fayo and Dapo, for putting this together. The controversy has been raging. I hope you have a lot of people on this platform who can listen to what is being discussed and take their cue from that. Let me thank Dapo for his introduction. He was very smooth, very clear, and the examples are very good. And also our DG of the Corporate Affairs Commission, Alhaji, thank you very, very much.
Alhaji Garba Abubakar.
Garba Abubakar. Thank you
Registrar General.
Registrar General, beg your pardon, for those words. Fayo keeps saying that I am the affected one. I think Wimbis is also affected. We are an NGO.
Yes, so you are right.
Thank you, Mr. Secretary, for those very clear. You know, and it's unfortunate that the church, especially the church, not even the mosque, the church in particular feels a little bit aggrieved and a little bit sensitive and a little bit sore about this particular matter at this point in time. The reason is that, like I said before, we knew from the time of the the FRC that was a little bit interested in what the church was doing. And it looked as though the church seemed to be making quite a lot of progress. The church seemed to be loud. Some of our pastors and leaders seem to be a little bit loud and also to some extent critical of government. So when the Financial Reporting Council came up with its own issues at that point in time, which were robustly debated, we had the opportunity to meet with them several times, many sittings and all that. Eventually, we were able to arrive at some kind of agreement or some kind of compromise with them. They came back, they seemed to want to change it again, and then we went back. And then that whole thing went up in a bit of smoke. Nothing happened. The fellow there, who incidentally was a pastor, was suspended or something happened. And then the whole thing went quiet. Then there was another regulatory body that was established again to look at this issue of NGOs. There were discussions, there were arguments, there were conversations. And then again, that one seemed to have died. So for this thing to have surfaced in CAMA, it was as though it was coming again, the same issue again from yet a different angle. And that is why a lot of the ministers of God and churches seem a little bit aggrieved. But like Dapo said, we need to look at it from a very professional and very practicable perspective. It is a regulation to deal with NGOs and non-governmental organizations. And as an auditor myself, I have audited for a few other organizations, certain NGOs that were not church, and their conduct was a little bit not quite becoming because they took money for something and they use that money to do other things. I will not mention any names at this point in time, because even some of those people that I audited at that time for Ford Foundation, they are not alive anymore. And it was a little bit of an embarrassment at that point in time. So it is not just the churches that are not, that are affected. A lot of other NGOs all over the place, a few of their members are not quite behaving as well as they should. And I was explaining to my assistant when he was asking me this question and coming again from the perspective of the church, this and that, I said to him that it is government's job to regulate and create a level playing field for everybody. And everybody is the business of government to make sure that what I do does not affect another person. And what DACO does not affect another person unfairly. That even if you smack your child unduly at home and the child complains to government, government has a duty to make sure that that child has been fairly treated. What we want to be sure, as we said, is that it is not targeted, is not discriminatory, and government is not trying to gag or silence any group of people or threaten their well-being. So what I'm going to say is that because Sheikh Al Maktoum says it's government's objective to make everybody happy, and we've had these kind of things before. Like I said before, in some areas, some people in government have a loud voice, and sometimes they can be a bit mischievous. Dako might remember a long time ago when all of a sudden the Institute of Chartered Accountants woke up and they were saying that lawyers must sign our accounts before they can be approved. Of course, we're very angry. I don't know which lawyer had the effrontery to try that.
let's not go into that debate. that was the initial CAMA, 1990, when CAMA first came out.
1919 CAMA, We were so angry that as professionals do a set of accounts, then I will take it to DACO to sign. And then DACO will then charge me a fee for signing the work I have done. But eventually we were able to overcome that. And I think that thing was reversed, which tells me that whatever has gone on today in this present CAMA can also be reversed or re-amended or retuned or fine-tuned, depending on who brings forth the argument. So what I'm going to say to my brothers in NGO or in church or religious organization who feel aggrieved is that we should come together. We should go through this new CAMA with a tooth comb. We should tell the government the aspects of it that we're uncomfortable with, the aspects of it that we will not accept, and we should have an argument with them. And we can take government to court if we want, if we're not satisfied with whatever they come back with. So we want to be, my advice is that we should be a little bit professional about it and face it from a very, very professional point of view. Unfortunately, we seem to have slept slightly on our rights, because when the readings were going on in Senate, in House of Representatives, nobody was really aware, or maybe we thought that the law might never come to light, and then suddenly somebody woke it up from somewhere, and so on and so forth. What do we need to do next is that we need to come together, think about this law properly, and come up with our own rights of reply to government and say, government, let us look at this again. But what I want to bring to the attention of my dear Registrar General at this point in time, and I'm glad that I have the opportunity to speak with you on this platform, is this. Number one, let us really understand what that section 839 subsection 1 says. Misconduct, mismanagement of the association. We need to properly define what will amount to a misconduct. Let's not leave it so general, okay, and so on and so forth. Let us also, like I said earlier on, understand that I said that fraud is fraud, but it depends again on interpretation. If, for example, my organization says to me that I can draw $10 million a month according to our constitution, and it is accepted by the members, and somebody from outside shouts and says, $10 million, it is fraudulent. Is it fraudulent or has it been accepted by my people? So again, we need to define what those things are and what the constitution of the organization says, okay, and so on and so forth. But you see, the truth of the matter is, like my sister, Mr. Adegbite, says, if there are processes, if there are procedures, if the organization itself wants to self-check, there should really be no problem. In my church, we do our audits on an annual basis. We file, or we try to file. We might be a little bit behind, but we will try and catch up with our filings. We have our processes, we have our procedures, and we try our best to make sure that it is what we're set up for that we try to deliver. And a lot of organizations should also do that. My only challenge, though, is that they are now asking us to submit accounts biannually. I must tell Registrar General that that may be a little bit steep and uncomfortable. You should please make this annually. If you don't mind, that is what we will prefer. If we need to do a formal representation about that, we will. It might be a bit tedious to keep asking an NGO. Some of them are very small, very tiny, to be doing accounts every half year. Every 6 months might be a bit onerous, okay? And that is where we may have a challenge. Even big companies do their own accounts once a year. Even those on the stock exchange, they can publish a half-year thing, but they don't submit or file until the end of the year. And then the other thing I'm going to also appeal to is that we need to be careful how we manage the information of an investigation into any organization. Because the minute you announce that an investigation has started in an organization, then the trouble begins to start and the organization begins to lose credibility and it begins to be demarketed. And especially if that investigation is spurious or mischievous. So I'm going to also ask that our Registrar General look at the process of managing investigations, because anybody can wake up tomorrow and say, this organization is being investigated, and immediately.
Oh, I'm sorry, we seem to have lost Pastor Itwa Igodalo.
Guilty.
No, he's back.
Before he's especially the way
1 minute.
So we need to look at that also. Aside from that, I don't have any personal problems with government trying to bring this law into CAMA. We just have to define it very well, be sure that we've crossed the T's, dot the I's, make sure that the law is clear, make sure it's not ambiguous, and give us a right to reply and respond to any area of ambiguity we find uncomfortable, and then we can move forward from there. Thank you very much. God bless you all.
Amen. Thank you very much, Pastor Itwa. You have spoken well. You have sent a message to the Registrar General CAC saying that biannual submission of accounts may be a bit onerous for NGOs. You have also asked that we define subsection 1 clearly, and possibly during the Q&A, the RG may take another look at that. Finally, you said this law, the CAMA 2020, should be well defined so that we make sure it is clear and easy for everybody to administer. Thank you very, very much, man of God. We appreciate that. And we see comments here that why don't we have an imam? Sorry, we do not have anything against the Muslim religion, but we may have an opportunity to talk to an imam also in the future. This is generally talking about NGOs, as Dapo Oyewumi has said, not a particular religion or the other. And in my place, there is a saying that the big masquerade dances last. So that would be the toga we would be giving the Nigeria Employers Consultative Association, the foremost voice of businesses in Nigeria. So they have said that is the toga. And we have with us Dr. Timothy Oshuolale Olawale, being ably represented by Mr. Thompson Akpabio. Just before you go on, Mr. Thompson Akpabio, who's a great friend at NECA, we would like to delve a little into the citation of Dr. Timothy Olawale. Dr. Timothy Olawale joined Nigeria Employers Consultative Association in the year 2011 as Director, Membership Services. Before that, he served as Executive Secretary, CEO of Hotels and Personal Services Employers Association, that's the HOPSEA, between October 2006 and March 2011. He was Group General Manager of Hermitage Group and its subsidiaries, and earlier on, Group General Manager of Kick and Ken Investment Company between 2001 and 2002. He pioneered the setting up of the famous Grand Hotels and Convention Center in Asaba Delta State, midwifing it from transition, then from the moribund Delta Hotels to a new concept and pride of the nation. Dr. Olawale is a fellow of the Institute of Management Consultants, member of Nigerian Institute of Management, and a member of the Chartered Institute of Personnel Management of Nigeria. As we have said, he is being ably represented by the head of the legal department in NECA, Mr. Thompson Akpabio. You're very welcome. You have the floor.
Thank you so much, Madam. Let me join to appreciate the organizers of this event, and I bring you greetings from my boss, Dr. Olawale.
Sorry, we can't hear you. Can you please...
Thank you so very much, Madam.
Okay.
Can you hear me now?
Yes, we can hear you better.
Thank you so very much, Madam. I bring you greetings from my boss, the DG of NECA, Dr. Olawale, who is unavailably absent. He had asked and given me instruction to represent him. I would like to align myself strongly with the submission of the very first speaker, Mr. Dapoye, and I concur in total with his submissions. Apparently, he has done a bit of the work for me. For the structure and organizations of the NGO tools for compliance, it appears that we can actually come under two of it. Number one, Section 26 of CAMA, limited by guarantee, or number two, Part F of CAMA 2020, which is the incorporated trustees. The objects are the same in terms of art, commerce, religion, science, research, charity, and all of that. So you may choose to register under any of them going forward for people that are yet to register. However, for those that are already in existence, they're expected to comply, even though there are a couple of differences in terms of when you're coming under limited by guarantee, you'll be expected to come up with your MEMAT and observe all the rules that are being in place there. However, if you're coming under the incorporated trustee, which is the Part C, there are a couple of things which you will need to also look into. Section 823 talks about its incorporations, the method of applications, and all of those things. Apparently, if we look at the current Act, the 2020 and the 2000 and the 1990 Act, the major introductions are in three key areas, which are things that are of concern to people. One of them is the suspension of trustees, and that is covered by Section 839, and it goes down. I do not toe the line of the Registrar General, with all due respect, because Section 839, sub 1, says that that the Commission may, by order, suspend the trustee. The Commission may, by order, suspend the trustee. The question now becomes, who made the order? Who gave the order? Is the Commission empowered to sit as a court to suspend or give an order? Now we jump down to subsection 2 of that same section. It says, the court, the trustees shall be suspended. Subsection 1 says may. Subsection 2 says shall. The trustee shall be suspended by an order of court. Now, subsection 2 has clarified it and given who makes the order that was left hanging in subsection 1 by saying by the court. And we read down to the other provisions of it, which is also in subsection 7. It also gives that. So if the law has stopped in subsection 1, then they would have been the umbrella power of the commission. However, there are some loopholes down there, because if we look at the conditions or the grounds, it talks about public interest. The question now becomes, what is public interest? Who defines public interest? Sadly, that definition is not in the current CAMA 2020. So would it be at the interest or the instance of CAC or the incorporated trustee NGO or even the court to decide this is a public interest, and then do not move over to look in at how to handle all of that? Well, I just leave that. The second aspect happens to be the issue of dormant account. On that issue of dormant account, that is covered, is also provided for in section 842 down. It's inspected that people should come up with ways of handling their account. On this note, I just want to encourage the incorporated trustees to involve and practice good corporate governance system within their organization. So that way they will look into all these loopholes and the lacunas that may actually be there. The other thing that has been introduced, which is also a new one, Pastor Ito Ighodalo has mentioned it, is the biannual filing of the statements of affairs. Biannual could be cumbersome. Biannual will take a lot of protocols. It has not stated, it has not defined whether it should be a fee, what the fee is. I know that will come up in terms of regulations that will be provided by CAC along the line, because CAC is actually empowered by law under this current CAMA to come up with two regulations. One in terms of its merger and acquisition of any two incorporated trustees association, and that's covered by section 849. And then the second regulation is also on the subject of that biannual filing of statement of affairs, which is in section 845. So we will look forward to having it, but it has to be fair. It has to be something that is doable and workable, so that people are not cumbersome with like, why do we go into this? Because a situation might arise where a lot of people are now running out of incorporated trustee. Let's liquidate this. Let's go and file under another name, or let's go and file as a limited by guarantee to continue the business in which they were actually in. It is not right. It is not wrong for the organizations to be regulated. Regulation is very fine. It's very welcome. It's encouraged, but it has to be fair. It has to be in line with the law and not by the whims of people. And when the law is somehow uncomfortable, it can be reviewed. I was a bit taken aback. I was taken aback when the RG said that there was no public hearing in the 9th Assembly on this particular subject matter. Yes, he alluded that there was a public hearing in the 8th Assembly on the same bill, but there was no public hearing in the 9th Assembly on the same bill, even if a word was, comma, or an apostrophe is introduced. It is expected that should have been a good public hearing for people to speak out and note the various changes that are the subject matter for the lawmakers. In conclusion, we just want us to each consider these 3 points as I begin to round up. Number one, the issue of trustees, the issue of structure, the issue of governance, it's expected that they should sit down, look at the new CAMA itself, like Pastor Ighodalo says, digest it, take it line by line, understand it, and have a community reading. What I mean by community reading is not just picking a line, but what does section 1, sub 2, does it have any inference with another subsection in other parts of the document? So you know what affects you and how you're going to handle it. Number 2, come on with a good corporate governance structure in the organization to be able to handle these things, especially when it comes into the biannual filing of affairs, so that you're not running foul of the law and they're not being picked up by CAC or any other regulatory agency. Then number 3, which is an area which I fear so much, is because they're going to see a lot of litigation. There might be an area of litigation on this new CAMA from various quarters, various bodies, various NGOs. But let it be in terms of interpretation. Let the courts interpret certain provisions of the law so that people know where to work and within the boundaries to which everybody is operating. There are rights, duties, responsibilities which people should operate with and know where their limits and their powers also lies. So with this form of interpretation, we will not be seeing a trustee usurping the power of CAMA. We will not see the CAMA we will not see a trustee usurping the power of CAC. We will not see a CAC usurping the power of the court. I will not see everybody running out and scatter any way they want, but they are operating within the ambit of the law of the land, which will be what we'll be looking forward to. I just want to leave it there as my preliminary comments.
Thank you very much, Mr. Thompson Akpabio. You have left 3 very salient points for the RGCAC to possibly react to. You asked for proper interpretation of this subsection 1 of the section 839. You spoke about filing of annual affairs. And then the third one, you said, I hope you are not a prophet of the doomsday, but you foresee an array of litigation, and I guess you are not the only one. Dr. Oyewumi has said the same, and I just wondered, probably before the law is eventually gazetted, the RG may have something to say about that. So as we prepare for the next set of questions, in fact, we are in the Q&A section now. Kike Obisheson will be coming up in a minute, but I have a small one here from Oreshofekun. Dr. Oreshofekun is asking, are churches allowed to set up hospitals and schools, or is that a misuse of church funds? As the RG comes on to answer some of these questions, please put that in your portfolio, sir. We would love to know about that. So Kike Obisheson, you have the floor.
Thank you so much, Mrs. Williams. Thank you so much. Thank you, Mr. Akpabio, and I want to thank all the speakers as well. Thanks so much. I'll just take some of the questions now that we're in the Q&A session. I believe this question is for the RG. It says, when exactly is the commencement date of the CAMA? We all know that it's not been gazetted yet, but people are really eager to know when the commencement is likely to be. Is Mr. RG here, sir?
Alhaji Garba Abubakar, sir, can you please unmute yourself? Yes, I think he's unmuted. Yes.
Thank you so much. We're still working with the Office of the Clerk of the National Assembly to ensure that really the act is quickly gazetted. As you know, is the responsibility of
to be losing him.
Okay, I think we might be having...
Okay, he's back.
So we initially were targeting, excuse me?
Sorry, sir, we lost you a bit, yeah.
We are liaising with the office.
Okay, again? I think we've lost him again. I think he might be having some connection issues on his end.
Let me start all over. I said, as you all know, in line with the provisions of the Authentication Act. Hello?
Yes, sir.
Yes,
you
sir,
can switch off your video. It may be better if you switch off your video. Yeah.
Okay, let me stop the video. Okay, fine. Yes, I said it's the responsibility of the clerk of the National Assembly to gazette this law, and we'll be liaising with them. We are trying to see if this thing can be done as quickly before the end of this month, so that the law will come into effect from 1st of October. So if we are able to achieve the gazetting before the end of September, then implementation will start by the 1st of October, hopefully. But if we are unable to do that, then it will depend on when we actually get it gazetted. But as I have said, it's actually the primary responsibility of the clerk of the National Assembly to gazette the law. But we've not just left it to them. Every day we are trying to find out what have they done, how far have they gone. And we are aware that petition has been submitted by the federal government press for the gazetting, and payment is supposed to be made in that respect. So this is the position with respect to the...
Okay, sir. What about the use of funds?
I don't know if I can respond to the remaining.
Yes, sir. There was a question about use of funds by church for hospitals. I'm so sorry.
Yes.
I'm sorry, sir.
The law is clear. Hello?
Yes, we can hear you better now. You said the law is clear on what, sir? Okay, I'm afraid Alhaji Garba Abubakar seems to have lost connection again. Kike, just before
sorry, Fayo. Okay. I think I can answer.
All right.
Okay. The fundamental document of any NGO is their constitution. And the constitution must contain the objectives of that NGO. So if the NGO's constitution says, we will establish churches, we'll establish schools, we'll establish hospitals and things like that, then they can do so. But if it is not in their constitution, then they may be a bit hard put to do so. They may need to amend their constitution to say. So the guiding document for any NGO is their constitution. For a company limited by guarantee is their memo and articles.
Memos.
So that should be the first, that should be the first stop to look at if they want to embark on any project or do anything. Let's look at our constitution. What powers does it give us? What objectives do we have there? And then from there, they can move forward.
Okay. Thank you very much. Back to you, Kike.
Much. This question was meant for Mr. RG, but I think we lost him now.
Okay.
Perhaps Mr. Oyomi can help, or maybe Mr. Akpabio. It says that what is the that why can't we have a separate institution governing the NGOs rather than lump business and commercial organizations together with non-profits under the same commission?
Yeah. So, Mr. Akpabio, if you could please answer that. I doubt if that's really to the RG.
Yes.
Yeah, that's really to the RG.
Yeah, but we can express our opinions.
Yes.
Okay.
Yeah, we can
so, Mr. Akpabio,
welcome.
Your opinion, please.
Basically, the CAMA is expected to regulate and ensure that business entities in Nigeria are registered, whether limited by public limited or private limited or limited by a guarantee or also incorporated trustee. However, if you look at CAMA, it has provided certain parts. When we had it in the 1990s, it had part 1, 2, and all of that. And the incorporated trustees were covered under part C. So they were like, what do you think related to those that are non-for-profits had their separate parts, so that they now look at, okay, these are the issues they should be considering, the requirements, and how they'll be operating. Currently, they're now being moved from C to part F as to the new 2020 CAMA, so that you have incorporated trustees there. So the issue of having two separate documents, I do not see the need for it. I'd rather say it's still good we have one document so that the same law is applicable to all of them. And then they now look at it and say, look, is what we're going to do. Because like Mr. Yomi said, if you are coming under an NGO and your constitution says you can do A, B, C, D, it will move out of ABC to do WXYZ. You're acting ultra-virus. And what will empower you to do A, B, C, D is your constitution. And what will regulate it is your foundation, which you have had in your registration. So having two different laws, two different documents doesn't really hold water, but there are already two different set of information provided in one law, but in different parts.
All right.
Okay.
Thank you very much. Mr. Akpabio. Kike, do you still have questions?
Yes, I have a couple of questions.
May I express my own opinion, please?
Provided you are going to allow us to overrun.
Oh, no, don't worry. My opinion is quick and straight to the point. No, we can overrun if people are here.
Okay.
I think Companies Act is for companies. And when we say companies, we're looking at business, commercial,
International.
yes, businesses, trading, commercial, business for business. And commissions, NGOs and all that should be regulated by a separate body because the nature of the operations are two different things. One is doing business and all that. So my view, I take the purist view. If you look at the Companies Act 2006 of the UK, it has nothing to do with NGOs and things like that. If you look at Ghana as well, they don't have anything to do with NGOs apart from limited by guarantee, which is considered to be a company. And then if you go back to then Ghana has the social welfare department to oversee the activities of NGOs. I think in other Commonwealth jurisdictions, that is what they tend to have. And before 1990, even in Nigeria, we had a large Perpetual Succession Act, which allowed for NGOs apart from company limited by guarantee. It was that there was no commission or body overseeing the activities. So if you ask me, my own personal opinion is that we should have a commission similar to the British Charities Commission that deals with, that deals with NGOs and charities, and let the Companies Act deal with business-related companies, and so that there's no, that's my own personal.
Okay. Thank you very much, sir.
Apparently, Mr. Yome is telling us that you have two different commissions, two different laws.
Yes, because I believe that the operations are different. Yes,
and then what happens to the incorporation? Which of them handles the incorporation, sir?
Alhaji Garba wants to come in, please. The owner wants to come in.
Okay.
Alhaji Garba, let us allow his own voice too. Yes, please, bring this, sir.
Yeah, we're actually not opposed to having an independent commission. But the issue is, government is talking about multiplicity of agencies. We're even implementing Orosanya report, where some of these agencies are being merged. So, and if we establish an agency strictly for charity, will that agency be self-sustaining? How many charities do you have? How many not-for-profit organizations do you have? And how much do they pay to even register? How much do they pay to file returns? So government will still need to subvent the operations of that agency. It may not be feasible in the immediate picture. Maybe in the long run, as we move along, when we have enough of these not-for-profit organizations, maybe from the returns, the annual returns they pay, if the money be realized will be enough for that agency to operate, because government doesn't have money to keep on establishing one agency after the other. Then let me seize this opportunity to speak to some of the issues that were raised by Pastor Iguodalo and the issue of biannual statement.
Also raised by Mr. Akpabio.
The agency will come up with regulations that will clearly define what misconduct is, what misappropriation is.
We seem to have lost him again. Sir, please put off your video. Please put off your video, Alhaji Garba, so that we can hear you better.
So these provisions, all this, the definition of what is misconduct, although the law has even alluded to what is misconduct, but will come with clear guidelines so that some of these trustees will be guided. Secondly, on biannual statements, this statement will not be in form of audited statement. It will be a statement of assets and liabilities as at the date or some few days before it is filed, similar to what we have under Schedule 14 of the Companies and Allied Matters Act as repealed for banks and other companies in the financial sector. So it's not going to be onerous. You may not require an auditor to prepare the biannual statement. So it will be a simple statement that will show the income and expenditure of the association for that period. So it's not going to be burdensome. And even if there is going to be any fee to be paid, I can assure you the fee will be a flat fee and it will be affordable. In any case, some of these NGOs are dollarized. So even if they pay higher, there won't be any issue, I believe, because some of their income. But we recognize that there are some that are actually small. that may not afford to make this payment. And that is why the law now gives CAC the power to classify these NGOs. The classification may be based on turnover, what they generate in air, and based on their own activities. These are actually the issues, and we'll consult. We won't do it alone. I have mentioned this at different forums that CAC will have stakeholders involved in the process of coming up with these regulations and guidelines. So we know our stakeholders, we know those that will be affected by this law, and we'll bring them along in coming up with these regulations. Thank you so much.
Thank you very much, sir. I now, Kike, are you still there with us?
Yes, I am.
I have some questions for Pastor Itwa. Can I squeeze them in?
Yes, please.
Pastor Itwa.
Well, okay. Please go ahead, ma'am.
Okay, thank you. I hope you are sitting very well on your seats because these questions are coming for you, sir. It says, why is church not ready to pay taxes? Jesus paid taxes and churches abroad do same. Number two, why should church not have corporate governance in place? The apostles recognized its importance and established it in the following scripture, which says, so let men of God concentrate on preaching and trustees handle other matters, including financial. Says the 12 apostles called a meeting of all believers and told them, it is not advantageous for us to be pulled away from the word of God to wait on tables. This is Acts 6, verse 2. So Pastor Itwa, an affected person, please, can you answer these questions for us?
Well, first of all, it is not correct to say that churches or members of the church don't pay taxes. The whole essence of a non-governmental organization is that the monies used thereof is used for largely charitable purposes, and it is not being divided by anybody as dividends. And therefore, government has given the leeway and the allowance for you to collect these monies and use it for religious and charitable purposes. However, anybody being employed by that charitable organization is liable to pay tax, is liable to pay tax. So the pastor should pay tax, the manager should pay tax, whoever is employed by that charitable organization should pay tax on the income that they earn. But the organization itself is not looked upon as an organization that earns income per se, but donations, contributions, offerings from the general public, which should also be used to further the interest of what that organization was founded for. Okay? So you don't pay tax out of something somebody donated to you. It is assumed that before they made that donation, they have paid tax and they have given you this donation so that you can in turn donate to other people and use for things that will benefit society and not necessarily a trading income. That is why charitable organizations don't pay tax as an organization, because they are set up for charitable purposes and not for the benefit of those who have set them up. It's a sacrifice from those people setting up that organization in the first place. So we need to separate that. And that's why churches don't pay taxes as a charitable organization. And that is why we go through the process of being registered. And that is why they are now trying to regulate those things to make sure that what you say you are registered for is what you do. The second thing about governance and corporate structure. It is not true to say that charitable organizations do not have governance. My sister, Mrs. Adegbite, has told us the length of governance that they have in WIMBIs, and I bear testimony to that. My sister-in-law and all the founders, they're all my friends. I know the amount of hard work Adiola Aziz and all of them do to make sure that they are totally above board, and they have different layers of regulation to make sure that they do not run foul of any law. And a lot of churches do that too. The Anglican Church, the Methodist Church, a lot of Pentecostal churches that are serious have a lot of structure, policies, processes, governance in place to make sure that people's funds in their care are well managed. I'm sure Dangote Foundation, Danjuma Foundation, all these MTN foundations, they would have very, very good structure. So in fact, some of them, if you ask them for money that is not within their purview of what they want to finance, they say they're not going to give it to you. They say we're set up for education and we're doing only education, health, we're doing only health, and so on and so forth. So I think that person is not quite correct to say that churches or NGOs don't have governance. They do. Those who have. That is not to say that they're not one or two who like our mom and pop shops and this and that. And I think it is those ones that is making the government a little bit uneasy and saying, let us make sure that there's proper governance and regulation in those places. But that is not a flat conversation at all. A lot of us have very, very good and strong governance. We have it in all my NGOs and in the church that I run, for sure, definitely.
Thank you for that clarification, Pastor Itwa. Kike, do you have other questions? As we come to the dying minutes of the webinar this evening. Yes.
I just have two questions for the RG. He's still here, and just just in case we lose him again, I think it's just better to ask him those two questions at the same time and have him answer them at once. The first question says that Mr. RG should please clarify the relationship between the right of the Commission to suspend by order under Section 839, subsection 1, and the requirement of suspension by order of court, or by that's under Section 839, subsection 2. So the participant who asked the question probably wants to know the relationship between subsection 1 and subsection 2 of Section 839. And the second question says that would it be ultra vires for an NGO to set up a business that is unrelated to their initial objective? For example, if a church sets up a school and is collecting fee and making profit, would it be ultra vires, and would they have offended any laws under the new CAMA 2020?
Oh, okay, thank you so much. On the first question, I have tried to make this distinction between 839 subsection 1 and 839 subsection 2. Our own understanding, and our understanding is based on the provisions of Section 76, subsection 1 of the Charities Act of the UK. That was where we got this provision from. CAC may suspend without recourse to the court on grounds of misconduct, misappropriation, fraud, public interest, or where it is desirable or necessary for the purpose of protecting the property of the association or ensuring proper obligation of this property. On that ground, CAC can suspend. But on any other ground, that is subsection 2, CAC will have to go to court to be able to do that. Then on the second issue of a church or other NGO establishing a school, if the Constitution does not provide as one of the objectives for which the NGO is being established, the establishment of educational institution, our position is they cannot establish. But nothing stops, because an incorporated trustee is a creation of law, and the law says it can make some income. It can actually own shares in a school. So where the organization being set up is a school established as a limited liability company that will be solely owned by the organization, and whatever dividends they drive will be channeled for the promotion of the objectives of the parent institution. Our own position is there won't be anything wrong, but the Constitution again has to provide that they can engage in this kind of activities. So to run a school side by side with their primary activity, they will require that provision to be in their Constitution. But to actually buy shares, because you have some of the NGOs, some of the richest NGOs actually control some of the blue chip companies that we have. Oh, yeah. They have investment in these companies, but the proceeds from this investment is not shared by the members. It's actually utilized to promote the objectives for which these organizations are established. So these are my answers to the two questions. Thank you.
Thank you very much, sir. I now hand over to Mrs. Fire Williams. I think we're done with questions for now.
All right. Thank you very much for your patience, everyone. It has been an awesome day, an awesome evening. We are very grateful to our erudite and knowledgeable speakers who have spared their time. Once again, I'll just run through. Just 1 minute, please. I just want us to run through this home stretch. Thank you for being such a worthy partner in bringing this education to the public. Can you see my screen?
Yes, we can.
Okay, so thank you very much, Dr. Oyewumi of Partners CLB. It has been great working with you. To RG, Alhaji Garba Abubakar, you have been so kind and patient to clarify again, particularly section 839. We are indeed grateful. We believe there are still so many questions, and somehow or the other we'll find a way of getting across to the participants, maybe with some of these questions answered. So I hope if we come to your doorstep, sir, you wouldn't.
Anytime. Thank you.
Very kind of you. And Mrs. Hansatu Adegbite, thank you for your time. We know that being a Saturday, as a woman of substance, you might have been, dishing out, I don't know whether it's a pankuko or a dikaiko in the kitchen, and also preparing for the boardroom. Thank God women are wearing multiple hats right now. Thank you for taking the funding question. And again, to Pastor Itwa Igodalo, it's been so wonderful having you. Thank you for saying that, yes, regulation is in order, provided it is fair and it allows for a level playing field, and all your points have been noted. Senior Pastor, Trinity House, Itwa Igodalo, thanks once again. And of course, Dr. Timothy Olawale was more than ably represented by Mr. Thompson Akpabio. He himself is a heavyweight, is the head of the legal department at Nigeria Employers Consultative Association, NECA, the voice of the private sector and businesses in Nigeria. Thank you very much. To our awesome audience, what can we say? It's been such a wonderful day, and we've been able to complete the agenda. As I round off, I'd like to remind you that Simply Exponential Consult Limited is into development program design and implementation. We have served a cross-section of clients, including the UNDP and LSCTF, Swedish Institute, She Works Here Accelerator, Obasanjo, Olusegun Obasanjo Presidential Library, I beg your pardon, the World Bank under the GEM project, as well as UK Aid and Deepen, Nigerian Directorate of Employment, and various others. We operate an innovation hub in the heart of Lagos mainland. It's called Exponential Hub. And I am, should I say, transmitting from Exponential Hub. We have fiber optic internet, so you can use this venue to run your webinars, trainings for small groups right now because of COVID-19 pandemic. And we would like to offer you our services whenever you would need them. We also have something coming up soon. This will be sent to you by email, starting a business right in Nigeria. If you're worried about losing money, you don't have to be, because you can learn from the experts. And I am finally signing off. My name remains Fire Williams. I'm a virtual event moderator, certified master trainer, and business setup expert. My handles are @FireWilliams on Twitter, Instagram, and Facebook. I would now like to hand over to Kike Obisheson as she takes us through the Partners CLB offerings as well. So Kike, about Center for Law and Business. Over to you. I'll operate
Thank you
the
very much.
this end. Just tell me.
Thank you very much.
Go to the next.
I just briefly, yes, want to introduce what we offer at Center for Law and Business. Could you please go to the next slide, Ma? Center for Law and Business is, yes, we are like an education hub. We provide access to world-class education. We have a passion to engender a better educated society, and that's that's essentially the reason why we collaborated with Simply Exponential Consult Limited to stage this webinar to enlighten the general public. Part of what we do, we offer teaching support to various world-class qualifications. Our flag bearer is the University of London undergraduate and postgraduate programs. We offer courses in law, business management, economics, business administration, human resources, and many, many, many more under postgraduate and undergraduate programs. So what we do is we give you access. You study with us in Nigeria. You don't have to relocate if you don't want to, and you get the same world-class qualification, especially for the University of London. It's not an online course, so it doesn't state an online on your certificate or nothing like that. So it's a traditional education, distance learning education system. We also offer professional qualifications under ACCA, CIPM, and many others. We also do offer recruitment services for top UK universities. We have a student fair coming up on 19th of September 2020, which will have all of these bodies. So as University of London, IOFP, that's the International Foundation Program for undergraduates who are seeking admission in UK, Canada, Middle East universities, but who just have their O-levels and have not done A-levels or foundation. It's like a very good pathway for students to seek admission in these universities without doing the 2-year A-level. It's just a 1-year program which is studied here in Nigeria and which parents also find beneficial because it helps them prepare the student for university life and attain an age of maturity before traveling abroad and being on their own. You can reach us at 18 Babatunde Jose Road, Victoria Island, Lagos, and also follow us on our social media handles at CLB Center on Facebook and Instagram, and also send us an email or telephone this phone number. As registrants for this webinar, you will be receiving an email that will send you the link to the recorded video of this webinar and also some other details on our business offerings at Center for Law and Business. Thank you very much for attending, and we say a very big thank you again on behalf of Center for Law and Business to the panelists. It was a very, very robust discussion. Thank you very much. Thank you, Mrs. Fire Williams.
You're very welcome. Thank you, everybody. Enjoy the rest of your weekend. Thanks to all our distinguished panelists. Bye-bye.
Thank you. Bye. Have a good weekend.
Bye. Happy weekend.
All those that I promised a wave, here's my wave, double wave.